District of Ohio with the Honorable Jennifer Tinsley presiding is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have a series of cases to be argued this morning. When I call your case, please stand. State your name, the party you represent, and your readiness to proceed. The first matter being argued this morning is actually a consolidated series of cases. They are C-25-0126, Newman v. Durrani, C-25-0127, Prater v. Durrani, and C-25-0128, Boone v. Durrani.
Phil Williamson on behalf of the appellant, please proceed. Ms. Aaron Herzig.
Good morning.
Alan Stavman and Ben Moran on behalf of the consolidated appellees.
You ready to proceed? Great, thank you. And then the second case is C-25-0198, State of Ohio versus Michael Desmarais.
Josh Thompson on behalf of Mr. Desmarais, ready to proceed, Your Honor.
Thank you.
And Jennifer Bishop for the City of Cincinnati, ready for argument.
Thank you very much. All right, we'll begin with the consolidated Durrani cases. Mr. Williamson, you may come forward. And each side will have 20 minutes to argue. Would you like to reserve time for rebuttal?
5 minutes if I may, Your Honor.
All right, you may proceed when you're ready.
May it please the court, Phil Williamson on behalf of appellant Dr. Durrani. There is no meaningful dispute about whether this court has jurisdiction, so happy to answer questions about jurisdiction if the court has any, but otherwise I would like to spend most of my time on the merits today.
I think we do have questions about whether the order below is a final appealable order. Can you just walk us through your analysis of that question and specifically the B8 subdivision?
Absolutely, Your Honor. So under B8, a final order is an order restraining or restricting enforcement on temporary, facial, as applied, any basis of any state statute or regulation. What you have here is a trial court order. So we've checked the unorder box. It states that the amended 2305.15 cannot be applied to Applebee's claims. So what you have is a trial court order that states the statute of repose and the amended absent defendant savings statute do actually cover the facts of the cases in front of you, but the court won't apply them, cannot apply them.
And so
They cannot be applied.
who is restrained or restricted from enforcing the statute?
Well, Your Honor, in this case, it is the defendant appellants that not allowed to enforce a statutory defense to the claims of Applebee's.
And so you interpret the trial court's order denying your motion for judgment on the pleadings as restraining or restricting your own ability to enforce that statute?
Your Honor, whether you want to describe it as the defendant getting to enforce a statutory right or the trial court declining to or refusing to enforce the statute, the outcome is the same, that the trial court's order declares that it will not and cannot give force and effect to the amended absent defendant savings statute or to the statute of repose. So while we think that the enforcement aspect here is really the defendant's ability to enforce his own statutory rights by raising and pursuing a defense, at the end of the day, like, the practical result is the statute is not being given force and effect in an area where it otherwise would have force and effect. And
How is this different from any other decision that a trial court might make in choosing between applicable laws?
Well, so Your Honor, in Section B8 assumes, I think, that trial courts are going to be choosing between applicable laws. If you look at what Section B8 covers, every single order that falls under B8 is going to involve refusing to apply or enforce a statute because it conflicts with either another statute or with the Constitution, or refusing to enforce a regulation because it conflicts with a statute or the Constitution. So every B8 decision is going to involve a conflict of laws.
So
but that's exactly what they're doing.
prior to B8, you would not have been able to appeal the trial court's decision, right?
Correct, Your Honor.
Okay. So now that we have B8, are you saying that in a situation where trial court, for example, the parties below say two different statutes of limitations or repose might apply, and the judge picks one over the other, that would allow for an interlocutory appeal under B8?
No, Your Honor.
Okay.
So in a situation where the court is, for example, choosing, as you said, choosing between two different statutes of limitations, it's not that the court is refusing to apply or failing to give force and effect to one law. Occasionally, the court might say, look, you have two statutes here who might have force and effect, and the Ohio Constitution or principles of jurisprudence tell us which one wins out, but that we are giving effect to the law. What you have here is the court simply saying, I have a statute that applies, and I'm not going to apply it here. It is distinct, I think, from a court finding, for example, that a statute doesn't apply. Suppose, Your Honor, Ohio passed a law tomorrow that said there can be no blue vehicles on the road. Two plaintiffs come challenging the statute. One of them is a driver of an orange car. The other is a driver of a blue car that he purchased before the statute went into effect. Both of those plaintiffs may win that case. One would win on the ground that the statute does not apply to me. It doesn't have a force or effect to give to me because I drive an orange car. The other might win because the statute's unconstitutionally retroactive, so you can't force against me even though the statute would apply to my blue car. You would have an immediately appealable order in the case of the blue car and not one in the case of the orange car. Why? Because there's no force or effect to give in a place where a statute simply doesn't apply. There is a force or effect to give to the law where the statute would apply and the trial court says, for generally a constitutional reason, I am not going to do that. This case is in that blue car territory, and those orders we submit are immediately appealable. And in fact, we think that's exactly what the General Assembly was after when it enacted B8 in the first place.
I'd like to get your perspective on the Ohio Constitution, Article 2, Section 28. Okay? So I want to understand your perspective on how this language applies. And the language is the beginning language. It says the General Assembly shall have no power to pass retroactive laws. So how does that apply to our case?
Well, Your Honor, I think the Ohio Supreme Court has made pretty clear over a long body of law that it is not a prohibition on all retrospective or backwards-looking laws, but that it is a prohibition on substantive retroactive laws, that is, laws that will in fact create or impair an existing right, but not as to, for example, procedural or remedial statutes. And we think we're squarely in remedial statute territory here.
Okay, so that's where, so you're saying this is a remedial statute
Correct, Your
because
Honor.
it affects a remedy? So you're defining, how are you defining a remedy here?
So it is a remedial statute because it's important to remember the General Assembly did not touch the statute of repose, which would be a substantive statute. It impacted the absent defendant and amended the absent defendant saving statute. That, the Ohio Supreme Court has told us, is a remedial statute. If I remember right, it was either in Ruther or in Elliott, that saving statutes are remedial statutes. And it's because they operate as exceptions to substantive statutes. So a statute of limitations defense is a substantive defense. You can create or destroy exceptions to that. The same is true with statutes of repose. The statute of repose, we know, creates a substantive right for defendants to be free from litigation. The General Assembly can create or eliminate exceptions, but affecting the exception is not a substantive statute. That is a remedial one.
Okay, so, because when I look, I'm going to go back to Article 2, Section 28. So that shall language, it says the General Assembly shall have no power to pass a retroactive law, but may. So it allows them under certain circumstances to do such, right? And in this case, the General Assembly is silent. It has not made it retroactive, right? It doesn't speak to retroactivity. So on the plain meaning, looking, there's no retroactivity, right? So why aren't we just done? Why doesn't that just resolve it?
Your Honor, that's where I'm going to have to disagree with you.
I haven't said anything. I'm asking a question. So you're not disagreeing with me. We're not in disagreement.
If the General Assembly gives no indication that a statute is to be retroactive, that would be the end of the conversation. I think the Supreme Court case law, especially in Van Fossen, is pretty clear. You need legislative intent for a statute to be retroactive that the General Assembly communicates to you.
And that's
then it's
what,
gotta be
and I
removed.
think so we're in agreement with that. We need legislative intent, and here, the General Assembly didn't say that it will be retroactive. The General Assembly said nothing, right?
No, the General Assembly did not say nothing. The General Assembly said it's the express intent of the General Assembly to overturn the decision in Elliott versus Durrani.
that
That's
a
not legislative
power-
history, that's in the
is-
statute.
Is that a power that the legislature has to invade the province of the judiciary by overruling its decisions?
Absolutely, Your Honor. The General Assembly absolutely has the power to say, Court, you got this question wrong.
By amending the statute, though.
By amending the statute, but it can do so.
They don't say what the law is. The Supreme Court said what the law is, or was, and then the General Assembly said, well, we don't like that interpretation, so we're going to amend the statute.
I mean, the General Assembly is, I would submit that, like, as the lawmaking power, the General Assembly actually tells us what the law is. The General Assembly tells us that there is a statute of repose and how long it lasts and what the exceptions to it
We
are.
interpret the law.
You interpret the law,
So the
and-
Supreme Court and Elliott interpreted the law as it was at the time. And the General Assembly didn't like the interpretation, so they amended it.
Well, the General Assembly doesn't think that the Ohio Supreme Court merely interpreted the law. The General Assembly is pretty clear. They think the Ohio Supreme Court changed the law, which is
Well, they
different.
can't, they can't do that. Courts interpret,
Your Honor,
right?
as the losing party in Elliott, who
Yes.
believes that both this court and the Ohio Supreme Court got it wrong,
Yeah.
I wholeheartedly agree that court can't make the law.
Right.
That has not always stopped courts.
Right.
And in many of those instances, the General Assembly will step in and say, no, what you have done is interpreted the law at odds with our intent, which is.
But the effect of that is an amendment. So they did amend the law, right?
Again, the position of the General Assembly, and this is in the legislative record, the position of the General Assembly is the Ohio Supreme Court amended the law when it issued Elliott, wrongfully, but the Ohio Supreme Court amended the law. It changed what the law meant, and the General Assembly acted to restore the pre-Elliott meaning of the absent defendant savings statute.
So you're saying they did not amend the law?
Our position is that it's a clarification, not the substantive text of what the absent defendant statute the absent defendant savings statute says at Section A did not change. What you get is a Section B clarifying this statute does not apply to toll statutes of repose. And then you get.
If your position is, and I think I'm understanding it, if your position is that the amendment overrules Elliott, then why would this be a retroactive application?
So, Your Honor, in the first part of our brief, that's exactly the point we make, that the court does not have to engage in retroactivity analysis at all. The statute of repose is untouched, unchanged, and clearly bars Appellee's claims. And what you have is the General Assembly making clear Elliott was wrongly decided, and the absent defendant savings
And
statute.
is that your position?
Yes, Your Honor.
Elliott was just erased and it just doesn't count.
Correct, Your Honor. That not merely legislative history. The uncodified section of HB 179 says the intent of the General Assembly is to overturn Elliott versus Durrani. And so, in our view, it means that Elliott is off the books, except as to the parties, namely Elliott.
And you believe the legislature has the power to undo judicial precedents?
I want to break that question down into two components. So, can the General Assembly declare this decision from the court was incorrect and no longer has force and effect? Yes. What the General Assembly can't do is unwind a judgment. So the General Assembly cannot say, you, Mr. Williamson, were the losing party yesterday. We declare by statute that actually you win, and the
A
judgment is
veto,
vacated.
per se, a veto. It
Exactly.
cannot veto a court decision.
Exactly. But the General Assembly can say, Mr. Williamson, you lost yesterday and was litigated to a final judgment. That decision was wrong, and it will have no further effect outside of the direct parties to that action.
All right, so that's your first argument is that there wasn't an amendment.
Correct, Your Honor. It was a
And your
restoration of
second
status quo
argument is
ante.
that even if we determine that there's an amendment, then what?
If you determine that it's an amendment, you have the General Assembly communicating its intent that the statute apply retroactively, and it is applied to a remedial statute unless you have a
So is it-
validly retroactive law.
So before this, if we say it's an amendment, before the amendment, these plaintiffs they could bring their claims, right?
Yes, Your Honor.
Okay. And so now those claims are extinguished
So what you,
by this amendment.
I think the court is actually starting in the wrong place there.
Okay.
Which is that what you have, the substantive right here, you have a substantive right to bring an action. Plaintiffs had plenty of time to do that and could have done so before the statute of repose expired. Once the statute of repose runs, plaintiff's right is extinguished by virtue of not being exercised, and the defendant now has a substantive right to be free from litigation.
Okay.
What the saving statute impacts is that defendant's substantive right. And so you can amend a remedial statute to vindicate a substantive right. And that's what you have. You have an amendment. It's not that plaintiffs have been sort of cut off unfairly. What you have actually is the General Assembly saying, we are getting rid of an exception to a defendant's substantive right, and they're allowed to do that on a retroactive
But
basis.
for this amendment, they could have brought these claims because they were told.
Your Honor, but for the plaintiffs could have brought the claims before the statute of repose ran. That's the point.
I understand that, but even so, because they were told previously, before the legislature enacted this new law, they could have brought these claims because of the tolling statute, right?
Yes, Your Honor. They
Okay.
could have brought those claims because of the
And
statute.
now this new law, with this new law, they can't bring those claims anymore.
That is correct, Your Honor.
So isn't that the problem here?
No, because again, I think the court is starting in the wrong place, which is these two statutes are about the substantive right of the defendant. And so you don't, number one, you don't have an unfair sort of impediment or reducing of a plaintiff's substantive right, because all the law guarantees the plaintiff has a substantive right to bring a claim within 4 years under the statute of repose.
And counsel, you're at time. Thank you.
Can I ask you a question, though?
Sure.
You pointed out in your supplemental brief that the legislature moved forward to overrule Elliott, okay? And you're arguing that, I'm not sure I'm clear on what you're arguing. Are you arguing that they were clarifying Elliott? What is it that you're saying that the General Assembly intended to do in overruling Elliott?
Your Honor, I think there are two ways for the court to reach the same substantive destination. The General Assembly was overturning Elliott and declaring that Elliott has no precedential effect and that it was an incorrect reading of the law.
Okay, and where is the General Assembly saying that it was incorrect?
It's in the General Assembly's declaration that its express intent is to overturn Elliott versus Durrani.
Right,
And
the
you
word
will-
overturn, okay, cool.
and
We're
if
good
you-
there. Wrong, where is that coming from?
So if you look at the sponsor testimony and the way that they explain why this statute is written,
Okay,
they say the Ohio Supreme Court added to the statute when it decided Elliott, and that the purpose of the amendment, or to the purpose of HB 179, is to restore Ohio law to its correct interpretation, which is the pre-Elliott understanding of the statute of repose and the absent defendant saving statute. But what you get from the sponsor testimony is the Ohio Supreme Court is the one that amended the statute. We are simply correcting that error.
okay. So the sponsor testimony is a subset of the General Assembly, is it not?
It is. You're right.
Okay, all right, I just want to make sure that I understand where your arguments are rooted with regard to this, okay? Because you cited to the Senate bill in support of wrong, and in your brief, so it didn't like get me there to where you were coming from, okay? So I wanted to clarify that. Thank you.
No problem, Your Honor.
Thank you. You'll have 4 minutes on your rebuttal time.
Thank you, Your Honor.
Thank you.
Shockingly, I see this differently than the appellant. Sorry about my voice, but having some sort of weird difficulty seeing a doctor.
There's a lot of allergies in the air,
They
or allergens, I should say.
had to use some scope, and they've got me on some medicine to cure a problem here. I don't know what, they don't define it, but
Can you start with the final appealable order? Because I noticed in your merit brief, you seem to,
well, I don't think it's a final appealable order.
why not?
Well, because I think it falls into the same category of things like a decision that affects the defendant on a statute of limitations, or on a directed verdict, or on a mistrial, or on a denial of a motion to dismiss, and on and on and on, where they don't suddenly get to come running to the Court of Appeals to get an early decision on those issues. And so I see this as not a final appealable order, and that the case should go forward just like any other case.
Is anyone restrained or restricted from enforcing the amendment outside of the context of this case?
I'm sorry, could you say that again? I didn't quite follow it.
Well, there's the new amendment.
Right, which would
That-
apply prospectively.
Right. In the context of this case, the trial court decided not to apply the amendment retroactively.
Correct?
Outside of this case, and I'll ask you a follow-up question in a second, but outside of this case, is anyone, by virtue of the trial court's order, restrained or restricted from enforcing the amendment?
Well, the amendment's not enforceable in this period of time from when the Supreme Court acted backwards. So the amendment is only prospective in nature. So it would be enforceable on cases that would violate the statute of repose prospectively.
Well, did the trial court stop anybody? I mean, is this like a preliminary injunction or something? Did the trial court stop anyone from enforcing the amendment?
Well, what happened is they filed a motion to dismiss based upon the amended statute, saying that based upon the legislature's ruling, the case should be dismissed, and Judge Reese overruled that and said he disagreed because it wasn't, in his opinion, to be applied retroactively.
The statute defining a final appealable order labels orders that, quote, restrain or restrict enforcement of a state statute. And I'm trying to understand if this order restrains or restricts someone from enforcing the amendment. Do you think that it does?
No, it does. That order is specific to that case, or these three cases, and how they may affect other Durrani cases. Doesn't have the effect of stopping others from doing that any more than a decision on summary judgment in this case is a non-final order and does not, it's a statute, it's stopping enforcement of the statute, and it's not applicable to other litigants because this court ordered the statute under the circumstances of this case to not stop the case. So it isn't something that can be universally applied as the Durrani law related to both the new statute and the amended statute of repose. It applies to these facts because the Supreme Court interpreted existing law to say that there was the ability to toll the statute of repose, and it was already there. And they made that decision. And so that's a substantive right that the plaintiffs had that was then taken away from them by amending 2305-15.
Can the legislature overrule a Supreme Court case?
Well, I kind of found that ridiculous that they couched it in those terms. They could have created a new statute, in essence saying that the legislature, look, we all know what happened here is the lobbyists went nuts, and within 5 months, all of a sudden, this comes out.
I'm not sure that the General Assembly is necessarily prohibited from overruling, because overruling has been defined as to nullify precedent or to rule against.
Well,
So,
I don't see
if
it.
they nullified precedent, it still is recognizing that it was presidential, and they now have decided to take the law in a different direction with this legislation.
Right, well,
So I don't know that, I don't know if that's an issue necessarily. That's why I think, what it means becomes very important.
well, I don't think it's
So,
a-
but I want to ask you a new question, if that's okay, all right? Everyone seems to be premising their arguments on that the trial court determined that the General Assembly had determined that B8 will be retroactive. And I want to draw your attention to some language in the trial court's entry. Because the trial court's entry says, furthermore, even if we assume that the first prong of the test of ballot was met here, and the first prong of ballot is that the General Assembly intended it to be retroactive. So if the trial court is saying that it's assuming it, is assuming it the same thing as determining that the General Assembly intended for it to be retroactive? I know that was a long question.
Well, I don't read it quite the same way. The way the court discussed it is that that one interpretation might be able to infer that they meant that it was retroactive.
So is that the same of saying that the General Assembly intended it to be retroactive, and now we get to the second prong
No.
of Bullet?
Not at all. Because here they say their intention is to overrule Elliott. And if their intention was to overrule Elliott retroactively because they knew there were 200-plus cases that are affected one way or another by this, and their intention was to apply it retroactively to take away the right to litigate those cases, I don't think they're so short-sighted that they wouldn't have come right out and said, this is to be applied retroactively. I think the fact that they did not say that, in essence, and I made a note in the margin related to this decision, that they purposely carved out the fact that these 200 people or so would still have a valid cause of action, and that this was clarifying how they wanted it to work in the future. Because they realized that there was a substantive element to the situation where even the appellants tell you in the first few pages of their brief that the statute of repose is substantive in nature. Now, they changed the tolling statute, but that directly affects substantive rights. So I see it as a legislature saying, this point forward, now everyone is clear on what we want. We see what the Supreme Court said. We don't like it, but we're not going to say in blinking lights it's to be applied retroactively and send these 200-plus litigants who have been litigating since 2013 home without a remedy.
So can you please share your perspective on whether this is substantive or remedial and why?
Well, I think that it's substantive because the way the statute of repose is set up and the limitations on it affect the substantive rights of these plaintiffs moving forward. And it's the plaintiffs that bring these claims. And so the substantive analysis, to me, is more of a plaintiff-oriented analysis than it is the defender. They have these substantive rights. They're the one that has to get the case rolling. No rights of the defendant are ever affected if there is no case.
They're arguing that the substantive right at issue is a defendant's substantive right secured by the statute of repose to have an absolute timeline within which claims must be filed. And that the second part of that is that the tolling provision is a remedial statute that affects how the substantive right is remedied. And their argument is that when the legislature removed the tolling provision, that all that it did was remedy a procedure by which the substantive right is secured. Do you agree or disagree with that?
Moving forward, not to the extent that it rips out from under 200 plaintiffs their substantive claims that have been being litigated for more than a decade.
So
I don't agree with
Can
that.
can we interpret the amendment differently in terms of its substantive character in pending cases versus its substantive character prospectively, or does the amendment have a universal character in and of itself? I mean, what you're arguing is that the character of the amendment changes based on how it's being applied.
Well, my recollection, and it may take me a second to find it, is that even if you were to decide under certain circumstances that a portion was remedial, how that's applied and affects the individual's standing in a lawsuit in terms of equity and fairness and their rights that existed is also examined. And so I have a problem with this just getting stamped remedial and 200 cases go into the trash can. I think that there's a broader analysis both under the Constitution and the case law that talks about remedial versus substantive, and that nothing is 100% black or white when you stamp it remedial in nature. There are exceptions, and we've laid those out in the brief, and I'm sorry that I don't think I can put my finger on it.
Are you arguing that your clients had substantive rights in the tolling provision?
Yes, because it unconstitutionally abolishes our vested and accrued rights to pursue claims against the defendant that were already in action and moving forward for decades. And I don't think that you can then apply it in a way that suddenly turns the spigot of this litigation off because the Supreme Court and the legislature became at odds over something where the legislature had these very simple task, if they wanted it to be retroactively applied, to put that in there. They specifically said, they went as far as to say, we are overruling a specific case. This isn't a new statute that we think will be helpful to all the citizens. This is the Dr. Durrani exception. We are now going to make sure that even people charged with felonies that flee to another country get the protection of this statute. It has no other purpose. And so I think that it clearly rips away substantive rights that have been in process for decades or more. And that's how the appellees in this case see it. And I think that in terms of assembling the building blocks to a decision by this court, there is ample law and authority to put together a decision that says exactly what I am saying, which is this affects substantive rights. Any aspect of it being remedial in nature cannot be looked at in a vacuum. It has to be looked at as to what was trying to be accomplished. And I don't think the legislature is that cold and calculating to say, we're siding with a fleeing charged felon who left the United States without a passport to get away from his criminal prosecution. I don't believe that's what they did. I think they clarified it in their mind and took away a right that will be applied prospectively so that nobody that had that existing right will be affected, because it's new. It's what will happen to others 4 years down the road. Thank you.
Thank you.
Your Honors, forgive me if I attempt to cover too much ground in this reply. First of all, the reason why the absent defendant saving statute is remedial is because the Ohio Supreme Court told you so in Wilson versus Durrani, paragraph 11. Saving statutes are remedial. The court doesn't have to go any further than the Ohio Supreme Court said saving statutes are remedial. I do not know where in the law or in opposing counsel's brief you will find this idea that a remedial statute can actually be substantive as applied. That simply doesn't exist. A statute is remedial
Does
or it's
the
substantive.
amendment have a singular character, or can the character of the amendment change from case to case?
It has singular character. It is a clarification of RC 2305.15. It simply impacts a singular statute, and that statute is either remedial or it's substantive. It can't be one or the other depending on, frankly, whether plaintiffs think there's a particular policy
So
outcome for
if
one.
that's the case, how, if at all, should we factor in that retroactive application will extinguish people's claims?
Your Honor, that's a bit of the litigation history that I think was obscured in the previous argument. Appellees had an opportunity to pursue claims against Dr. Durrani. We're only here, and the statute of repose cut off their claims only because they decided mid-litigation to voluntarily dismiss them and go hunting for what they viewed to be a more favorable jurisdiction and more favorable judges. But we document this in, for example, the history in Jones versus Durrani or any of the recent joint trial cases. This is not cutting off claims that plaintiffs never had a chance to bring. They brought complaints and did not want to continue litigating in Butler County. The consequence of the strategic decision to dismiss those claims was that the statute of repose then came into operation, and this is what we litigated in Wilson. What you have is the General Assembly saying that the sort of take back in the application of a different tolling provision in Elliott was wrong. And the General Assembly can absolutely tell the court that they
Didn't
got
they
it wrong.
make that strategic decision with Elliott in mind? I mean, Elliott was the law, right, at the time?
No.
Or
They
that
made-
issue had not been decided?
They made that strategic decision years before Wilson was decided. In fact, that strategic decision is the reason why Wilson works its way through the court system. I have to emphasize, the General Assembly makes the law. The court's job, and I could give you half a dozen Ohio Supreme Court cases saying the court's job is to give effect to the intent of the General Assembly. The General Assembly can absolutely come back and say, court, you did not do that. You did not, in fact, give effect to our intent in writing the statute, and to the extent we feel it necessary, we are now going to explain exactly what our intent was and has always been. And that's what the General Assembly communicated when it used the word overturn. When it used the word overturn, it indicated Elliott was wrong. That's exactly what this court did less than a month ago in Finner. when it overturned its prior set-off decisions. And no one questioned that this court's decision in Fenner cannot reopen cases that have gone to a final judgment, but does apply to all cases that are still pending in the court system, of which we have brought no few since the Fenner decision came down. Everyone who encounters the phrase, "this decision is overturned," knows exactly what that means.
In
It means
Fenner, didn't this court expressly say that it was wrong? And I don't know that the General Assembly has done such.
So, Your Honor, there is some analysis of the
So
court's
rule
indicating that
could
it's
be
wrong.
for different reasons, right? So,
No, I mean, generally, the phrase overturned is almost always, I can't, I'm struggling to think of an example where this hasn't happened, where the conclusion is the decision we're overturning was wrong. I can't imagine a court saying the decision was right and it's overturned. And in fact, when the General Assembly thinks that the Supreme Court
but in
was
doing so,
right-
doesn't it acknowledge that it was presidential before that?
Well, Your
Not
Honor-
all, again, which gets us to retroactivity, right?
Your Honor, that's what I was going to get to
Yeah.
next, is that we do have examples of the General Assembly disliking the outcome of a decision, but thinking that the court did read the law right. And so you have statute after statute where the General Assembly says, we respectfully disagree with the Supreme Court's decision here, where we supersede the Supreme Court's decision here. This is to vindicate the Supreme Court's decision in another case. Overturned, I think, is materially different from those other decisions.
So maybe what it
Overturned is
comes down
indication
to is that whether the General Assembly was recognizing it as president or not. I think maybe that's what it really comes down to, and how that is connected to overturn.
But I think the General Assembly recognized Elliott was decided. Like, you can't pretend that Elliott didn't happen. But the General Assembly was communicating, Elliott happened and Elliott was wrong. Elliott is going to be applied in the future because that's the decision the Supreme Court issued, and we do not want Elliott to have continued effect.
So are you saying that when the General Assembly overrules,
Overturns.
overturns a decision of the Supreme Court, that necessarily makes it retroactive, whatever it is that the General Assembly then passes?
Yes, I think that the use of that phrase, overturned, as opposed to something like supersede or even disagree with, is an indication that the decision is in. That the
So
statute
that's
is
interesting,
in.
because then I'm trying to fit that into the Balat test, which it's not really the Balat test, because the Balat is citing the real root of that test. But because there, it's first is, whether the General Assembly intended it to be retroactive, and what the trial court, I guess this is really the heart of my question, is I'm looking at the trial court's entry, and I would really appreciate your perspective on something that's in here. And what the trial court wrote was, the General Assembly did not expressly state that it intended for the revised version of RC 2305.15 to apply to cases before its effective date. And the courts will not infer that a statute is to be applied retroactively from suggestive language. So tell me what to do with that. What does that mean?
The trial court was wrong. The trial court was wrong on the question of whether overturn clearly communicates an intent for the statute to apply retroactively. And I think that the trial court was wrong in that respect, because the reason overturn gets used here.
So the heart of your case, of your argument in this discussion, is that when the General Assembly overturns, that necessarily means that that new statute is to be applied retroactively. And the story, we're done.
Yes, Your Honor.
Okay. I thank you for clarifying your position.
And counsel, you're out of time if you'd like to wrap up.
The General Assembly made clear Elliott was wrong. It set out to overturn Elliott using the same language this court or the Ohio Supreme Court would use to accomplish the same task. And so all we ask is to give effect to the General Assembly's intent and reverse the decisions below. Thank you.
Thank you. Thank you very much for your advocacy this morning. We will take the matter under submission and issue a timely decision. Our next case is State versus Desmarais. Good morning. You may come forward. Would you like to reserve time for rebuttal?
5 minutes, Your Honor.
All right.
May it please the court, counsel, this is a case that from its inception was rife with avoidable but ultimately fatal errors in prosecution of Mr. Desmarais. He was charged under the umbrella section of an OVI for per se violations for the amounts of drugs one has in their system, 4511-19A1J. He was ultimately convicted without there ever being an amendment to the charge of what the trial court wrote as 4511-19A1J2. We raised 3 assignments of error, but what this boils down to is that Mr. Desmarais was convicted of the A1J, which is not an offense. It is the lead-in to several subsections that include prohibited levels of various drugs that one cannot have in their system while driving a motor vehicle. So,
How does the bill of particulars inform the A1J charge?
well, I think that it spells out what they thought, but actually works against them because they still didn't bother to amend the complaint, given ample opportunities to do so.
And there was no motion to dismiss filed alleging a defective charging instrument, was there?
There wasn't, but there was argument to have the state amend the complaint, and the state argued that it could proceed under different theories of A1J, which it cannot.
And counsel didn't appear confused about what those theories were, did they?
They did not, but I'm not arguing necessarily that there was any sort of surprise or lack of notice, but effectively a defective complaint and a finding of guilt under a subsection that it isn't an offense.
All right, so your argument as to the defective complaint is what then?
It's a little novel, I admit. It is essentially that the court was divested of jurisdiction because they never amended the complaint. For instance, like the Finch case that I cited, unlike that, this was never amended under Criminal Rule 7D. Finch was amended to a date subsequent to the original complaint. So that became defective. Here it became, so what I guess I'm saying is a complaint can become defective. And that's what I'm arguing here, that this became defective because they never bothered to fix it. If I see, I understand that that is an unusual argument because it's typically in jurisdiction to start the case, but I do think that the Finch case leaves room that, if you can amend a complaint anytime up to the end, then I would argue jurisdiction can be divested if you never actually amend the complaint.
So do you agree then that when the citation was filed and it said A1J, because it's my understanding factually they didn't have the urine test back yet, so they didn't know what substance, they didn't know what to allege at that time. Do you agree when it was filed that the complaint triggered the court's jurisdiction?
Yes. You can't, like you said, you can't know what drugs may or may not have been in someone's system at the time of filing the ticket.
And so then at what point did it become defective?
At the guilty finding, effectively, here, given the arguments below, although not a motion to dismiss, repeatedly a request to have the state pick a subsection to proceed under. And instead, an argument that you could proceed under every single drug as an alternate theory, and then just pick one at the end.
Did the lab report was disclosed as part of discovery, right?
Yes,
Okay, so defense counsel knew the substances that were disclosed in the lab report.
as did the state, and
And,
therefore knew the subsection it could amend to.
all right. And then those subsections were actually disclosed in the bill of particulars too?
I believe so. I don't remember exactly.
Okay. And then my reading of the transcript is that on the record in finding the defendant guilty, the trial court said the accurate subsection, but then failed to write it down correctly?
Correct.
Would you agree with that?
I would.
What do we do with that, with the fact that orally, and I understand the trial court speaks through its entries, but that orally, the trial court said the right section, but then wrote down something different, and so this kind of looks like maybe a clerical error.
I think the court has to reverse. At the end of the day, what's written is what the court is saying. I know that it may seem ticky-tack or picky, but that's what we do. I mean, they wrote A1J2, which admittedly wrote in uppercase, but in the lowercase form, which is the only way it could be, it would be cocaine. That's not what we have here. If you add the VII, then you've got marijuana, but that's never charged or amended. So,
Doesn't Criminal Rule 36, I believe, allow the trial court to amend its judgment at any time to conform to the facts at trial?
it could have. We went through quite a few appearances in court to get here. But it's divested of jurisdiction once we get this notice of appeal. So at the end of the day, it didn't do it. So I think I'll reserve the remainder of my time and just ask that the court reverse and discharge Mr. Dismaris.
Thank you.
Good morning. Jennifer Bishop for the City of Cincinnati. The decision of the trial court must be affirmed because the complaint is not defective. The complaint complied with Criminal Rule 3 when it was filed. It contained a written statement of the essential facts constituting the offense. It had the numerical designation of the statute, and it was filed under oath. So the complaint was sufficient pursuant to Criminal Rule 3. The complaint was also sufficient to invoke the jurisdiction of the municipal court. The revised code section says that municipal courts have subject matter jurisdiction for misdemeanor offenses that occurred within the territorial limits of the court. So the complaint clearly stated that it occurred in Hamilton County, and that it was a misdemeanor offense. So the complaint was not defective. The complaint was sufficient to invoke the jurisdiction of the court.
And this issue, the jurisdictional one, was not raised by a motion to dismiss, was it?
That is correct. It was not raised in the trial court at all. So the defendant's, or the trial court decision has to be affirmed because the trial court had subject matter jurisdiction. The decision of the trial court also has to be affirmed because the judge correctly ruled that the court could proceed on alternative theories under the A1J section. The lab report supported that the defendant had amphetamines in his urine. The lab report supported that the defendant had marijuana metabolites in his urine, and the testimony of the officer and the stipulations was sufficient to prove that the defendant was under the influence.
Why not, I mean, to the defendant's point, why not amend the complaint and pick a specific subsection of J to go to trial on?
Well, as a trial attorney, I never know what is going to be persuasive to the judge. So the fact that the facts supported three different theories, I thought the judge should hear the three different theories.
Could you have added additional charges? So could you have brought this as a J2 and a J81 and a J82 and just had 3 counts?
Yes, ma'am, that is possible, but I think that the law in this state is that the prosecution does not have to elect. There is a revised code section that says that the prosecution does not have to elect, and there's precedent from this court that says that the state can proceed on alternative theories, and the case law that I'm referring to specifically was in the OVI context. So yes, it was possible to proceed on different theories, but I don't think that case law and statutory law required it. So again, the decision of the trial court is correct and it should be affirmed.
And do you agree that the trial court's notation of J2 on the judge's sheet appears to be a clerical error?
That is the state's position, yes. I think the judge clearly in his analysis of when he was delivering his decision clearly stated that he was finding the defendant guilty of the A1J8. 2, I think, is the section that deals with marijuana metabolites. That's what he articulated from the bench. I would also point out to the court that on the written entry, he in fact writes the portion of the statute that goes to specific, the nanograms of marijuana metabolites. So I think the leaving out the 8 in his written decision was clearly a clerical error.
What should we do about that? Can that be corrected?
Oh, absolutely. I think it.
Should it be?
Oh, yes. I think it could be corrected with nut proton entry that because that's exactly what that stands for is now for then. I think that when the judge made his ruling, that is what he said. It's just not what he wrote. And I think that set out in the brief is another statute that would permit the court to correct the clerical error. So that is what I am asking the this court to order if you find that what the judge wrote is not sufficient to but I think what the judge wrote is sufficient and that this court can affirm the decision of the trial court.
It's the wrong, he wrote the wrong statute, though.
Yes,
So
ma'am.
But you think it's sufficient?
Well, he also wrote the correct, I think he made a factual finding, and his factual finding that's written on the judge's
Oh, okay.
sheet.
That combined with it, you think is sufficient?
Yes, ma'am.
It doesn't, so you don't really think, your first argument is that we don't need to, it doesn't need to be corrected because of that additional factual finding?
Yes, ma'am.
Okay.
That's my argument, if you all don't have any further questions. Thank you.
Thank you.
Factual finding 12-6-24 says 726 nanograms of metabolite. I don't know what that is. Is it cocaine? It wasn't, but that's what the statute that was written is.
Can you tell me again why you don't agree that, I mean, the judge stated the correct statute in the record, right, when he found guilty. Why can't he fix this on his judge's sheet?
He could have.
No, why can't
'Cause it's
Why
too
can't we
late.
send it back to be fixed now?
Because the order was final and it wasn't fixed, and therefore he was found guilty of a statute that was not applicable.
Well, not on the record.
Right, but that's, that's what we have. We have a final order. There is no fixing it. That's a double jeopardy problem.
So you don't think this is a clerical error?
I think that you can't tell. Honestly, I know that he said what he said, but what he wrote, and that's precedent is that what they write is what they mean.
But isn't precedence also that if the record isn't consistent with the entry, that it could be corrected non-proof tunc?
Well,
What
which part of
makes-
the
what
record are we
makes this-
picking? Are we picking the complaint, the ticket, which, by the way, doesn't state any facts, it's just a ticket? So, where we have to just pick. I mean, we're faced with any drug we want. The judge says one, the state says they can pick any theory they want, and then we write down something entirely different. It's not that hard to get it
Did they
right.
say they could pick any theory? I mean, didn't the Bill of Particulars narrow the complaint to 3 specific substances? It notified the defense of a theory under J1, which is 50 nanograms of meth, and then J8-1, which is being under the influence and having 15 nanograms of marijuana metabolite, and then J2, which is just 35 nanograms of marijuana metabolite.
Again, it doesn't fix the defective complaint. I mean, these things matter. If it says, we indict you for killing John Smith, but it turns out it's John Johnson, you got to amend it, you got to fix it. That's the person that died. So it is not a fixable error at this point because there was ample opportunity. And I'd also point out that the state cited, I know they said it in court, they didn't say it today, but this is what they were talking about, State versus Scruggs, 1984 Ohio App Lexus 9455. Both charges in that case were, that both complaints were filed, an A1 and an A3. That's not what happened here. If you want to go under alternate theories, you file all the charges. And
Do you have any case law that supports that the state is required to file a count for each and every theory?
not that I cited, but I mean, that's plainly obvious. You can have alternate theories for why you were, say, complicit. Say, I gave you the gun and I was the getaway driver. But those are factual differences, not entirely different drugs that we're just picking from a list. So no further questions. I'll ask the court to reverse and discharge Mr. Dismaris. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.